Yeah, hi, good morning. And I decided to skip the podium because I have a lot of text on my slides. So I wanted you guys to be able to read it. I know I'm not following the canons of good presentation, but this is a slightly complicated topic, so it's important to share some of the actual stuff with you. Uh, yeah, I need the clicker. Oh, here it is. Oh, great. Yeah. Okay, great. Okay, so let's just get moving. So, I think we all know what the context is for having a data protection law. Clearly, I think with all the huge expansion we see in digital space and the kind of data that's being collected, we do need to have legal provisions to protect the data of individuals. And all of this got a fillip when the Supreme Court of India, privacy as a fundamental right in a case which they looked at a couple of years ago. Pursuant to that, the court also recommended to the government that they needed to have a good data protection law in place, and the government therefore set up a committee to look into this, and I had a privilege of being one of the members of that committee, which was headed by Justice Srikrishna. Some of the good things about the whole process that was followed, one was it was a very consultative process. So the committee put out a white paper on what are the issues involved and got a lot of feedback from people across the country. We had consultative sessions in 4 metros and hundreds of people participated in that. So the good news is that a lot of useful inputs went into the preparation of this data protection report. And the other important perspective that we took in this report was to realize that India is a little different. On the one hand, we are not the US, where you generally have very high-level laws, but you don't really have very specific laws for things like data protection. The US tends to give a lot of emphasis on individual rights because of the way historically the country was formed. So we are not the US at one extreme, and we are not China on the other extreme, which is sort of completely paranoid about security, and therefore security concerns tend to dominate all their thinking on a subject like this. So we needed to be somewhere in between, where we protect the rights of individuals, but at the same time, we want to unlock the benefits of a data-driven economy, because that's very important to the growth of the country. That's very important for a lot of things we want to achieve. So we need to be somewhere in between, where we are balancing the rights of individuals and, of course, also making sure that there are no major hindrances to the use of data in the economy. So the overall objective was to unlock the data economy while keeping data of citizens. To do with the internet, because obviously traditionally countries have had laws, but when you're operating in internet space, where does one country's boundary end and where does another country's boundary start? These kind of issues become quite complex and you need to be grappled with. So clearly, when you're looking at a data protection law for India, one thing you've got to look at is that who are the people you will cover by this law? And what is the kind of data you will cover? So the first sort of definition we have here is that we will look at personal data that has been used, shared, disclosed, collected, or otherwise processed in India. So that's of course a simpler one because we are clearly drawing the geographical boundary there. But what happens if the data fiduciary is not present in India? So one definition is important here. When it's your data, you are called the data principal because you're the one whose data is being shared. And the data fiduciary is the one to whom you are sharing the data with. And we are calling them a fiduciary because we are giving it to them with some notion of trust that they have to take care of that data and use it in our interest. So you are the data principal and the entity with whom you're sharing the data is the data fiduciary. So the next question is, what happens if the fiduciary is not present in India? So there the approach is to say that the proposed law shall apply to those carrying on business in India or for other activities such as profiling, which could cause privacy harms to principals who are based in India. So we are certainly here looking at entities which may be outside the boundaries of India, but are carrying on business in India, which means they are providing services to Indians, they are targeting Indian customers, even though they're geographically located somewhere else. Of course, clearly any Indian data protection law would apply to Indian corporate entities. So irrespective of where the data is processed, if the company is incorporated under Indian law, then that's certainly an entity we would look at under an Indian data protection law. And of course, we may also make certain exceptions because we clearly realize that there is a thriving BPO industry in India which is handling a lot of data which is coming from outside. So though the data is being processed here, it's actually the data of people residing in other countries, and we would therefore like to make a provision that the government can exempt such companies which process the personal data of foreign nationals who are not present in India. So this is a bit of a tricky one because clearly we don't want to harm or hinder the BPO industry from functioning, but at the same time, clearly one would like to keep some eye on these kind of guys as well. So another tricky issue is what do you do with public and private entities? So clearly, when you're talking about private companies, a data protection law with very clearly defined rules and so on makes a lot of sense. But lots of us have concerns about the government as well. So remember that a lot of the issues with regard to data protection in India came about because of Aadhaar. And a lot of the Aadhaar data, not a lot of it, all the Aadhaar data is actually stored by the government. So one of the concerns you naturally have with any law is that it should in some form or the other cover the government as well. This is a slightly tricky issue. I'll come back to this a little later. One of the arguments which is often made in the context of data protection is that if you anonymize data, then maybe you don't need to worry about data protection too much anymore. So particularly when you're aggregating a lot of data and you're not really having identifiers there which enable you to associate that data to particular individuals, there should not be a problem. So that's by and large okay, as long as the anonymized data meets certain standards. Because one of the concerns people often have is, yes, it might look anonymous, but is it possible that somebody has the key to reintroducing the identities of people into that data? So you need to have some standards to ensure that the data is genuinely anonymous. If it's genuinely autonomous, it could be outside the purview of the data protection law. But if it's just de-identified data where the identities have been removed, but somebody has the key, then you need to be careful. Then there still needs to be some control of the law over such data. Now, one of the important things we discussed a lot in the committee was, are there different categories of data? And how do you classify them? So there is obviously certain kind of data we are all more concerned about. And we try to classify that as what we call sensitive personal data. Now, this was one of the most tricky lists to make because clearly different people have different views about what sensitive personal data is. And if you look at the kind of political, social, cultural context of India, then many things which might not otherwise be personal data start looking quite personal here. So if you see that this list is probably a bit longer than one would ideally like, but this is finally the list of sensitive personal data that we came up with. So it includes things from the financial domain, health domain, obviously gender, but then more controversial things in the social sphere like caste, tribe, religious beliefs, etc. So these are all in the list of what we are considering sensitive personal data. And I'll again come back to you in a minute to tell you what is the significance of this sensitive personal data. Also just note at the bottom there's a note that the DPA, which is a Data Protection Authority, which is one of the entities which we are proposing should be set up, that this should have a power to notify further categories if required. That's just an enabling provision. Now, any good data protection law in the contemporary space obviously relies a lot on consent. Because clearly what we want is we want people to be able to have control over their data. So the data should be used only in accordance with or with the knowledge of the data principle. So therefore, the basis for processing personal data in any data protection legislation will, or we recommend, should be based on consent. And one issue here is how do you look at consent? Do you look at the person or the data principle as an owner of the data? Ownership has a lot of connotations under the law, so that's a bit tricky. So what we adopted in this report is that we will instead follow a product liability regime whereby the data fiduciary, or the one who's processing or handling your data, is liable for harms caused to the data principal. So essentially, it's just like a company who sells you a product and something's wrong with the product, they're responsible. Similar, the data processor or the data fiduciary here is responsible for responsible handling of your data. And consent has to meet certain criteria. Consent, as has been clearly mentioned here, needs to be free. So you shouldn't have any barrier to giving consent. It needs to be informed, it needs to be specific, it needs to be clear, and it needs to be capable of being withdrawn. All of these are important. It shouldn't be a one-time thing that you just give it out and you can't withdraw it later. Now, one of the important issues in data protection is the fact that today we have a lot of people who are kids who are also part of the internet economy. And we need to protect their rights a little more carefully than perhaps we protect the rights of adults. Now, one of the challenges here is how do you define who is a kid and who is an adult? Obviously, in the internet economy, it's a little strange to say that 18 is the age for an adult, because we know, and in all our discussions, we keep realizing that digital natives are starting very much younger, and people are also maturing much earlier. However, in this particular proposed legislation, we finally decided to go along with the age of 18 to be consistent with other Indian laws. For example, in Indian law, if you want to be part of a contract, you need to be 18 years old. So a lot of things in the commercial world run on contracts, and in a way, what the data fiduciary is doing for you is also an implied contract. So though we were not completely happy with this age restriction of 18, we decided to suggest that a data principal below the age of 18 will be considered a child. And obviously, any data fiduciary needs to keep the best interests of the child in mind. We have created a special category here who are called guardian data fiduciaries. So if a data fiduciary is capable of causing significant harm to children, that entity would be identified as a guardian data fiduciary, and we are suggesting that some slightly more onerous requirements be put on the guardian data fiduciary because of the potential harm that could come to kids from such entities. Of course, all data fiduciaries will have to have an age verification mechanism and obtain parental consent, except in the case of guardian data fiduciaries who are exclusively offering counseling services. Of course, this again could be a challenging area if people are misrepresenting what services they offer, but we realize there are some services for which parental consent may not be ideal or may not be required. So what is a data fiduciary supposed to do? Obviously, a data fiduciary must process data in a way that is fair and reasonable. We would probably place some limitations both on how they can collect data and the kind of purpose that they are going to use the data for. And clearly, these need to be stated upfront. And particularly if you're planning to process personal data using big data analytics, that's something which needs to be disclosed at the time of collection. It's also desirable that there is transparency on data fiduciaries regarding how they are going to be using the data at different points of time. And particularly, a data fiduciary is expected to provide notice to the data principal if they are going to change the kind of use they are making of the personal data. We would also expect that there would be limitations on data quality and on storage. Storage, here we're talking about, for example, how long you keep the data. So once the purpose of data is over, you don't expect the data fiduciary to be holding on to that data anymore. However, the responsibility for checking accuracy rests with the principal, and the principal is expected to keep track that the data fiduciary is maintaining the correct data. Now, one of the things we are, of course, quite accustomed to these days is, unfortunately, data breaches. And obviously, any data protection law has to take this into account as well. So what we have proposed is that there will be a certain criteria under which a data breach notification has to be made by the data fiduciary. In the first instance, he would make this notification to the Data Protection Authority, and then under certain circumstances would also have to make it to the data principal. This is to prevent too much of chaos happening every time there might be some small inadvertent leakage of data. Obviously, there would be data security obligations which will be overseen by the Data Protection Authority. A good data protection law needs to have the ability for data principals to access their data, to confirm their data and to correct data if it's wrong. So this is something, a provision which you would expect to see in the data protection law. You would also expect a right to data portability, which means that the data can be transferred from one data fiduciary to another, but obviously that would be subject to certain limited exceptions. And certain other rights we felt were not explicitly required because we are covering them under the overall consent mechanism. Now, one of the most controversial areas of the whole data protection law has also been in this area of cross-border transfers, because as we know, in many cases, data is actually being transferred from one entity to another, which might be outside the country. You can take something like credit card transactions, for example, where clearly a lot of data is getting processed elsewhere, and that's the way many of the credit card companies already work, where their process happens in some other country. So cross-border data transfer will obviously be allowed, other than critical personal data, and I'll be coming back to that in a moment. But there will be model contract clauses containing key obligations, with the transferor being liable for harms caused to the principal for any violation that happens by the transferee. The central government will have the option to greenlight transfers to certain jurisdictions. So if they believe that that other country has an equally strong data protection law, and it's okay for data to be transferred without explicit approvals every time, you can actually do that. But there will be certain data which, if it is critical, will be subject to the requirement only to process in India. Now, this is again another very controversial issue, but it's largely expected to have very limited kind of scope. For example, if there is personal data regarding the armed forces or intelligence agencies or people like that who are critical to the security of the country, then you may not actually allow that data to be transferred across borders under any circumstances. So you might like to put a more stringent or a more strict restriction in such a case. So the central government would determine categories of sensitive personal data which are critical to the nation. That's the one I was just talking to you about. Personal data relating to health, however, would be allowed to be transferred in the law itself, because clearly there would be emergency situations where you might have to transfer such data, and at that time you cannot be getting special permissions and authority and so on. Other types of personal data will be subject to the requirement to store at least one live and serving copy in India. This has been one of the really controversial recommendations of this committee, and it's also been part of many other changes we have been seeing happening in the environment. For example, the Reserve Bank has already mandated that companies who are in financial services need to maintain one set of data in India, preferably the main set of data in India. It's happening in multiple areas now. It's happening in credit cards. And the RBI has been the most, or you should say the strongest in requiring that one copy of the data be stored in India. So many people wonder, why is there so much fuss about this data being stored in India? From my understanding is that the main issue is the challenges in dealing with entities who do not have a presence in India. So when you are, for example, having a data fiduciary who is outside the boundary of India, and let's say there's some data which is being stored by that entity. Now, if there is any question by the government, by the courts, by any entity in India about that data, then usually those data fiduciaries take refuge to the law of their country and refuse to share that data with Indian entities. So this has become one of the reasons why you are having this particular requirement here. Though I personally am a little uncomfortable with this, because it seems to be somewhat against the broad principles of the internet. If every country starts saying we want data to be stored in your own country, then you can just imagine how many copies of data you'll have to maintain all over the world. At the same time, there does seem to be a genuine concern, particularly with some of the large and very influential data fiduciaries, that they are not really being very cooperative with Indian government, with Indian law enforcement and security and so on. So that seems to be the main reason why, notwithstanding all the challenges of the internet, people are still thinking that we should have this live and serving copy in India. Now, of course, in any law, there will always be some exceptions, some areas which don't require consensus, don't require consent from the data principal. What are some of these areas? One of them is functions of the state. Another one is compliance with a law or order or a court or a tribunal. Now, here the most important thing which you should realize is that we are only recommending that these don't require consent if these are covered by a law of the country. Remember, a law of the country has a very elaborate process through which it's enacted. It has to go to Parliament. It has to be discussed. So if the Parliament in its wisdom has a law which allows the government to collect data for certain purpose, then we are saying it should be outside the scope of this. But if it should not be something which is just by executive order or just by a notification by the government. It is something that should be covered by a specific law or act of Parliament. Again, employment could be recognized as a separate ground for processing because we realize there are situations related to employment where the kind of effort required to get consent may be disproportionate. For example, you're doing a reference check. You might need to do that check without every time going back to the person whose data is concerned. Of course, there is also finally the residuary ground called reasonable purpose, which are not covered by other grounds like consent, compliance, etc. Finally, of course, one important area is exemptions. There will always be exemptions in such an act. Security of the state is one important thing. Here also there was a lot of debate in the committee, and there was some discomfort in giving a blanket exemption for security. So what the preference of the committee was definitely that this should also be something which is mandated by law. It should not be something which the government can just give an order and do it. It should be something which falls under the legal framework. Only then should this exemption exist. Similarly, for prevention, detection, investigation, and prosecution of contraventions of law, for the purpose of legal proceedings, an area which might be relevant to some of you is this one here on research activities. So there was a sense that, yes, there should be some kind of exemption provided for research, but that should not be used as a smokescreen behind which people are illegally collecting and processing data. So research should be an exempt area, but with certain criteria, with certain checks and balances, which the Data Protection Authority would be expected to look after. Personal or domestic purposes is an obvious exception. You don't want to, for your kids, you don't want to have to take their permission to take their data, for example. So obviously that's something which needs to be exempt. Journalism is another one, a little bit like the research category, where clearly we believe in freedom of the press, we believe in right to information. So we would like to give, of course, some exemptions to journalism. But again, I presume some checks and balances would be required in that domain as well. And last but not the least, manual processing by small entities, where the whole burden of meeting these kind of laws would be very onerous, and the benefits would be quite limited. Finally, the last topic I want to cover very quickly is enforcement. Obviously, no law works unless it is enforceable. In India, we have a very, very impressive list of laws, but many times they're not very effective because they're not enforced properly. So obviously, enforcement is a very significant part of any new legal framework. So for data protection to work under a legal framework, we recommended that a separate data protection authority should be set up as an independent regulatory body. This would be like SEBI or the insurance regulator or any one of the independent regulatory bodies that the country has set up over time. These are the functions which the DPA would perform: monitoring, legal affairs, research, inquiry, grievance handling, etc. The DPA is the one which will have the power to categorize certain fiduciaries as significant data fiduciaries. Now here what we have created another category where we are saying there are some data fiduciaries who are just extremely important. I don't need to name them. You all know who they are, with whom we are sharing lots and lots of data almost every day. So those data fiduciaries will probably have some additional regulatory requirements. They would be required, for example, to register with the DPA, give certain returns and things like that. And these are the criteria we would use to identify those significant data fiduciaries. Basically, a huge volume of personal data, the kind of personal data they're collecting, their turnover, the type of technology they use, etc. So these significant data fiduciaries would be expected to undertake obligations like registration, data protection, impact assessments, record keeping, data audits, appointment of a data protection officer, and so on. So this is just like a large company needing to have an internal audit and an audit committee and all the rest. So any large data fiduciary needs to have all these things internal to their company so that they have control processes within the organization as well. Obviously, in India, every entity which has any judicial powers also has an appellate process. So we would expect to have an appellate tribunal. We'll also expect to have appeals to the Supreme Court as the last stage of inquiry. And obviously, there'll be penalties. By and large, all the violations of the proposed data protection law would all be civil offenses. So typically, the kind of punishments you would have would be fines. Here again, we have a tricky problem. Many data fiduciaries don't have an Indian entity, or at best they have a small entity which does some marketing here. The real meat is with the parent data fiduciary who is somewhere else. So here it is envisaged that the penalty could be based on the turnover of the parent entity and not on the small entity which is perhaps in India. Okay, obviously they'll have other enforcement tools, they'll have powers, they'll have an adjudication wing and things like that. So this is basically the kind of structure which is proposed for the entire data protection law. The status of this is that the Data Protection Committee submitted its report in July 2018, and it's now under consideration by the government. As you know, for this to be converted into a law, government has to propose a bill and present it in Parliament. Parliament will debate it, and then finally a data protection law will come into being. We, in our report, gave both a report as well as now the next steps are to the government to take this forward. But we expect that many of the provisions that we suggested will in some form or other figure in the final law. Though obviously it's the government's prerogative in how exactly they want to frame this particular law. Those of you who are interested, I recommend the report to you. Report is a pretty voluminous report, almost 200 pages, but it explains in detail all the things that I just mentioned to you very briefly. And it's very well written, so it's good reading for those of you who are interested in this subject. So thank you. I think I have just 2 or 3 minutes left, but I'm happy to take any questions.
So just a question on the topic of consent, right? Most of the time, consents just, you check the box of terms and conditions, right? And I believe that I'm a person of reasonable mental processing capability, and even I'm unable to understand those 100 pages of terms and conditions because these brands have hired an army of lawyers whose only job is to make it very confusing, right? So how are my rights then protected in that case? Because I can't understand those terms and conditions. And more importantly, as mobile and internet grows in this country, most of the people it's going to are unable to read and write, right? So how are those people those people protected?
Yeah, so I think that's a good question. Obviously, any data protection law will require a consent framework, and consent is a tricky business. So I think what we'll basically be saying is, if, for example, if you're dealing with sensitive personal data, you can't just have a checkbox thing where you say, is everything okay, and you click. You'll at least have to take out the salient points for that and maybe one by one get people to respond to that. It might become a little more complex for the user, but at least thereby you're making sure that the specific things you're actually consenting to. The Data Protection Authority will also mandate certain suggested methods of obtaining consent, also probably some suggested formats. So there, hopefully over time, will be some improvement in the kind of consent mechanisms that are in place. So it will be between the DPA and, of course, the law to ensure that the consent is not the kind of boilerplate thing that you're talking about, but it's more specific. But yeah, there will be a little pain for the user. So sometimes if you want to use one of those things, you will actually have to click multiple times to specific clauses to make sure that you actually read and know what you're consenting to. Yeah, last point, I don't know. There's no alternative to improving literacy. You can't create a digital country if you don't have a literate country. So I think sometime or other, you'll have to address that. Yeah, please. Yeah.
Hi, my name is Puneet. I have a question. With regards to Data Protection Act, what we are actually talking about in India, it's more or less like a global phenomenon. In Europe, what we have seen is GDPR. In US, we are talking about California and Singapore and multiple other countries. You know, people are trying to address this particular problem in their way. Is it fair to say that our DPA is also going to be more or less on the same premise, so that for global companies, it is not going to be a bespoke implementation, but is going to be a generic global framework which actually adheres to the local norms?
I think that's going to be a little difficult. What I can say is, obviously, when we came up with our recommendations, we were quite influenced by GDPR, for example, because clearly that's one of the most detailed frameworks which already exist. So you will find quite a few things of the details that we are suggesting have some similarity to what has already been adopted by GDPR, though we wanted to reduce a little bit of the complexity because GDPR appears to be quite complex. But at the end of the day, to answer your core question, I think unless different countries start discussing these issues and coming to some agreements on standardization of these legal provisions, or at least some commonality of approach, the kind of utopia which you're looking at, that it'll be very simple, I think may not quite happen, at least to start with. It'll take a little time for more harmonization to actually happen. Thank you. I'm seeing one red light blinking there saying time's up. So let me hand over to the organizers. Thank you.